Welcome to the lecture German and International Company Law. In the next few sessions you will get a comprehensive overview over the core elements of German, European and broader international company law, especially concerning the most important legal types of companies. In this first podcast you will get to know the fundamental principles of company law and the law of the partnerships. We will begin with the fundamentals of company law and the basic terminology. A company is an association of one or more natural and legal persons on a contractual basis with a common focus. The basic definition for German company law can be found in Section 705 BGB in the context of the general partnership, which we will examine in more detail later on. However, the basic features laid out in Section 705 BGB also apply to companies which are not partnerships. You can see the definition with the highlighting of the most important features on the slide. By a partnership agreement, the partners mutually put themselves under a duty to promote the achievement of a common purpose in the manner stipulated by the contract, in particular without limitation to make the agreed contributions. A company normally has a sole purpose to generate profits and to further the economic goals of its members. Because legal persons can form a company, it can also comprise of several other companies as members. There are also possibilities to form groups of companies to further coordinate economic activities. In a systematic sense, company law is part of civil law. The founding of corporations is part of a contractual freedom, and therefore general contract law also plays a significant role in company law. There are also huge overlaps with labor law, as the organization of company may oftentimes be influenced by statutes concerning determination by workers. We will now take a look at the different sources of company law in Germany and abroad. In Germany, as in most other jurisdictions of continental Europe, the most important source of company law are the statutes passed by Parliament. Germany does not have a unified company law code, but has specific codes for most types of companies. The most important codes which regulate parts of company law are the German Civil Code, BGB, the Commercial Code, HGB, the Limited Liability Company Act, GmbHG, and the Stock Companies Act, Act G. However, there are significant overlaps as German law operates with a system of general rules applying to all specific cases if there is no definitive regulation within the specific code. For example, both the GmbH and the AG are merchants by virtue of their legal form in the sense of the Commercial Code and operate under the same rules as a single merchant. Another example is that parts of the Stock Companies Act can also apply to the limited liability company because of the similarities between the two legal forms. When dealing with cases concerning company law, a lawyer therefore needs knowledge of all the statutes and their overlapping areas. But also in the Anglo-American legal tradition, statutes play a huge role in modern times. The situation is not as clear-cut as the general saying suggests that civil law countries rely more on statutes while common law countries operate by case law created by judges. Reality is much more complex here. In the UK, at least in England and Wales, company law is mostly shaped by the Companies Act of 2006, the Partnership Act of 1890 and the Limited Liability Partnerships Act from 2000. In the United States, on the other hand, there is no unified company law on the federal level. Every state has its own legal system and its own company law. On the federal level, there's only minimal legislation on the basis of the Commerce Clause of the Constitution regarding capital markets law. That is the trade in shares and investor protection. Most of it was originally enacted during the New Deal era, in part to curb the wild speculation, which contributed to the stock market crash of 1929 and the subsequent Great Depression. The most relevant federal statutes here are the Securities Act of 1933, the Securities and Exchange Act of 1934, and the Sarbanes-Oxley Act of 2002. Especially the last one is also of importance when dealing with big American companies abroad, as it imposes very strict standards of corporate compliance, also concerning overseas operations. It can impose certain restrictions in the choice of business partners for the American companies. For example, if there is even the suspicion of fraud being committed by a potential partner. It is therefore especially important to have a good compliance system in place when dealing with big American companies. Apart from these very limited regulations concerning interstate commerce, company law is original jurisdictions of the 50 states, so that there are as many legal systems. 24 states follow more or less the Model Business Corporation Act, MBCA, which was designed as a suggestion by the American Bar Association, but is no hard law. However, many big companies are incorporated under the Delaware General Corporation Law. This is due to the fact that the US Supreme Court has ruled that corporations can incorporate under any state law regardless of their actual administrative headquarters. This has led to a regulatory race to the bottom, which Delaware decided in its favor in recent decades due to its very lenient tax laws. Due to the huge number of incorporated firms in Delaware, the lawyers and courts in Delaware have developed a huge amount of expertise in their field. This makes Delaware especially attractive besides the regulatory advantages. In our last podcast, I will introduce you to recent developments in European law, which might herald a similar development in the European Union within the next years. Speaking of European influence, it is important to realize that the European law has had a huge impact on the development of German company law over the last 70 years. The European Union has several possibilities for legislative acts. The most powerful one is the regulation, in German Verordnung. Regulations are directly enforceable in all member states without the need for national institutions to enact legislation. Individuals can basically rely on regulations as on national legislation. An important example for a regulation concerning company law is the regulation on the statute for a European company of 2001. That's called the Societas Europea, or SE. With it, the European Union established the Societas Europea, the European company, a separate company type for the European Union. We will talk about it later in some more detail. The other and more indirect mode of European legislation is the Directive, in German Richtlinie. The Directive does not enter into effect directly, but has to be adopted by the national legislators and integrated into the legal system of the member state. There are exceptions to this rule, but which are not relevant for the current lecture. Concerning company law, there have been numerous directives which have been integrated into German law in recent years. A good example is the directive on the exercise of certain rights of shareholders of listed companies, or short, the Shareholders' Rights Directive. Its purpose was, among others, to encourage shareholders into participating more in company policy decisions. Member states, for example, had to guarantee that shareholders could put items of the agenda of the general meeting and have the right to vote by proxy in the meeting. Apart from statutes and supranational legislative acts by the European Union, the most relevant source of company law are the decisions of courts. The rulings fill the statutes with meaning and determine the actual application. Traditionally, this case law has had a huge significance in common law jurisdictions like the United Kingdom and the United States. However, as pointed out earlier, this clear-cut separation no longer really applies. In Germany, the Federal Court of Justice, BGH, has shaped the development of company law for a long time. Besides that, the European Court of Justice, ECJ, or in German EuGH, continues to have a huge influence on the development of company law within the European Union. Traditionally, case law has had a much more important place in the legal framework of the European Union than in many member states. Especially during times of slower political integration, the European Court of Justice has furthered the legal and economic integration of the European Union. We will take a look on the development and the significance of the European Court of Justice jurisprudence in the last podcast, when we will talk about the freedom of establishment within the European Union. In company law, there's another major source of law, and these are the articles of association that have been developed by companies, lawyers, and notaries over time. Because companies rely on cooperation, it is much more harmful for the overall purpose if the parties are pushed into litigation. A bitter fight in the courts among partners or shareholders often eliminates what little is left of trust, and further cooperation becomes untenable. Because of that, much more care and time is invested into designing articles of association, which try to balance conflicting interests and provide means of resolving conflicts before they escalate. The standards which are developed in this process over time shape the application of company law. Clauses which have proven themselves are integrated into collections of standard clauses and used as templates for new companies. Another point to consider when talking about company law is the so-called soft law. As the name suggests, soft law is not binding on the parties involved. It can, however, shape the expectations and the behavior of the relevant circles. The most important piece of soft law in German company law is the German Corporate Governance Code. In German, Deutscher Corporate Governance Codex, DCGK. It contains repetition of already statutory binding law and recommendations and suggestions for responsible corporate governance. It's aimed at companies which are publicly listed and which operate on the capital markets. Its foreword lays out the objectives. The German Corporate Governance Code, the Code, presents essential statutory regulations for the management and supervision, governance of German listed companies, and contains internationally and nationally recognized standards for good and responsible governance. The code aims to make the German corporate governance system transparent and understandable. Its purpose is to promote the trust of international and national investors, customers, employees, and the general public in the management and supervision of listed German stock corporations. In the long run, it aims to establish a certain standard to further the trust in the capital markets and encourage more widespread investment. In the German Stock Companies Act, there is a provision which refers to the code. Section 161 Act G. It established the so-called comply or explain model. The management needs to inform the public annually if they comply with the governance standards laid down in the Codex. If they do not follow the standard, they have to explain themselves to the public. In this way, the capital market is informed about the trustworthiness of a publicly traded company. This kind of soft pressure, the standards of the DCGA essentially have to be followed, because otherwise the trust of investors and thus the ability to finance itself will be severely decreased. Now we have established the different sources of law, which are the background for the following podcast. Next, we will take a look at the different types of companies which exists in one form or another all over the world. In German law, as in most other legal systems, there is a differentiation between partnerships and corporations. The defining characteristic of partnerships is the importance of the actual persons involved. The law does not grant the partnership an own legal personality. This means the partnership is dissolved if only one partner remains. A partnership necessitates multiple persons involved, which is a major difference in comparison to the corporations. Another marker of this dependence on the partners is the personal liability of the partners for the debts of the partnership. At least that is the regular model. The credit of the partnership is not guaranteed by a separate stock of capital as with the corporations, but by the personal credit of the partners. This leads to another characteristic, which is the inside management. Because of the unlimited personal liability, partners normally don't want to entrust non-liable persons with the management of the company. The partnership can only be managed by one or multiple partners themselves. The exact authority to represent the partnership can be regulated in the partnership agreement. Because of the liability structure, normally all partners have an equal voice in decision making and in principle need to agree on every decision. However, this can also be amended in the partnership agreement to suit the needs of the individual partnership and, for example, introduce majority decisions instead of unanimous decisions. In general, because of the personal liability, the partners have a large degree of contractual freedom when designing the partnership agreement. It's their personal responsibility, so they shall be allowed to manage their affairs as they would their own. There are just few limitations imposed by law and by the general principles of partnership law. The character of a corporation or capital company, on the other hand, in the eyes of the law, is not shaped by the shareholders, and especially publicly traded companies have a high degree of fluctuation in their membership. They have a legal personality on their own, and because of that, they are not automatically dissolved if there's just one shareholder left. In fact, they can be formed by one person on its own. The shareholders are not liable for the liabilities of the corporation and can only lose their pledged capital. The management is conducted through a board structure which is oftentimes staffed by outside managers. In contrast to the partnership, the limited liability allows for management by non-shareholders. But of course, shareholders can also perform management functions. Both roles are, however, treated separately by the law. In Germany and many other jurisdictions, there are requirements for a minimum capital that a corporation must possess. The function of this requirement to provide a certain basis for credit apart from the lacking personal liability as with the partnerships. This is, however, more theoretical, as the minimum sums are often not really significant in the grand scheme of things. Some legal systems, like the United Kingdom, therefore, do not have minimum capital requirements. And also Germany had adapted its law to allow for smaller corporations without minimum capital. Now we will turn in more detail to the partnerships, as they are the most basic form of company and can be formed without the formal requirements of a corporation. We will not go into details here, as partnerships, at least in the commercial sector today, are not nearly as relevant as corporations. German law provides for several different kinds of partnership, which may be divided into two general categories. Commercial partnerships, which carry on commercial activities as defined by sections 1 et sequence of the Commercial Code, and non-commercial partnerships, for example, partnerships under the Civil Code and non-trading partnerships under the Partnership Act of 1994, which serve all other purposes. Section 705 BGB apply to non-commercial partnerships. Commercial partnerships are governed by sections 105 subsequent HGB. The rules generally applicable to associations govern particularly matters on which the Commercial Code does not provide specific provisions. The partnership under the Civil Code, Gesellschaft bürgerlichen Recht, or GBR in German, is the basic form of all partnerships. Thus, its law serves to supplement the more specific provisions governing the other legal forms of partnerships. The partnership under the Civil Code is established by a contract between partners, who can be natural or legal persons. A notarized contract is only necessary if real property is contributed. The partners must agree on a common purpose pursued by the partnership. A common example is the common work of several companies on a bigger building or construction project, so-called Arbeitsgemeinschaft, ARGE, ARGE. Any legal common purpose except the operation of a commercial business is permitted. If several partners operate a commercial business, they automatically qualify as a general partnership, OHG. Partners are free to decide which matters shall be regulated by the partnership agreement. It's the principle of freedom of contract. The agreement may be amended by unanimous decision unless the partners have agreed on majority voting in advance. However, this rule is only applicable to operations in the ordinary course of business, or to those decisions explicitly mentioned in the partnership contract. Unlike partnerships operating a commercial business, a partnership under the Civil Code may be structured and operated as a purely internal partnership. In respect to his or her relationships, both to the partnership and to the individual partners, each partner is bound by a general duty of loyalty. Subject to specifications in the partnership agreement, partners may make contributions in cash, in kind, or by rendering personal services. In the absence of any agreement to the contrary, the law provides for equal contributions. A subsequent increase of the original contribution is only permissible with the consent of all partners. The partnership has only a partial legal personality and hence no corporate organization. As the law stands, the general partnership under the BGB cannot be registered. However, there is a proposal to reform the law of partnership and give general partnerships the possibility to register if they want to operate on the market and purchase real estate. The assets belong to the partners in joint ownership, so-called Gesamthandsgemeinschaft. The principle of joint ownership means the holding of property by two or more persons, not in distinct shares but jointly, each having an identical interest in the undivided whole. An asset may be transferred only with the consent of all partners, which can be given either in the partnership agreement, for example, by authorizing the management to dispose of assets, or in a general meeting of the partners. The law provides that partners manage the business jointly, but the partners may agree to entrust one or more partners with the management of partnership. Third persons may not be managers. The partners agree on the scope of authority of the management. If the partnership contract does not provide otherwise, the authority to manage the business is combined with the authority to represent the partners, so-called Vertretung. The partners representing the partnership act in the name of and for the account of all partners. The power to represent the partners in joint matters of the partnership may be restricted, while the personal liability of the partners may be eliminated by agreement with the creditors. It can neither be excluded by limiting a partner's power of representation nor by the partnership agreement. Partners acting beyond their power of representation are liable themselves to the creditors. The partners are personally, jointly, and severally liable to the partnership's creditors. As the partner's liability is accessory to the partnership's liability, each partner may be sued directly for the full amount in dispute. The personal liability of the partners may be excluded only by a formal agreement with the creditors. For this we can take a look at a short example. The German Energy Advisors GbR is formed by Adam A., Benjamin B., and Christian C. The GbR purchases a car from Daniel D., who is liable for the purchase price. With what we said before, it is certain that the GbR itself is liable for the purchase price. But because of the personal liability of the partners, every one of the partners also can be held accountable. This means that we have a liability of the GbR, 100%, the liability of A, of B, and of C, each 100%. Of course, if a partner needs to pay to a creditor, he can compensate himself with the partnership and the other partners. That is, unless the partnership agreement states that he has to bear the burden all by himself. Next, we will take a look at the OHG, which shares many characteristics with the GbR. The General Commercial Partnership, in German Offene Handelsgesellschaft OHG, is established by a contract between the partners. The partners must agree on the operation of a commercial business under a common firm name. Because of historical reasons, members of so-called liberal professions like lawyers, doctors, auditors, and tax accountants are not considered commercial in the sense of the HGB, the German Commercial Code. Therefore, they cannot use the OHG for their professional purposes. They either have to use the GbR or the partnership company, in German Partnerschaft, Partnerschaftsgesellschaft, which is provided for in an act on partnership companies of members of independent professions, Part GG. Due to the limited importance for your professional focus, we will not look at the specifics of the Partnerschaftsgesellschaft. Concerning the content of partnership agreements of the OHG, the contributions to be made, Section 105 HGB refers to the law of partnership under Civil Code. The partners must apply to the local commercial register for registration. If the partnership starts to conduct businesses before registration, the partnership is deemed to be effective immediately with regard to third parties. This means all rules regarding the OHG apply from this moment on. Similar to the partnership formed under civil code, partners of a general partnership, general business or commercial partnership, have a duty of loyalty both to the partnership and to their partners. The duty of loyalty is complemented by each partner's right of equal treatment. The law provides that the management is carried out jointly by the partners, but here too the partners may appoint one or more from their midst to assume the management of the partnership. Third, persons may not be managers, as we have seen before when talking about the general characteristics of partnerships. Each managing partner may represent the partnership in and out of court. His or her powers to represent the partnership with regard to third parties are unlimited and cannot be restricted through special provisions in the partnership contract. In contrast, the powers of managing partners may be limited internally. Managing partners who do not observe such internal limitations are liable for any damages caused to the partnership. A managing partner may be dismissed for cause by final court decision. To make this differentiation between internal limitations and external power of representation, we have a short example. Adam purchases a Chelsea tractor in the name of the energy advisors OHG. Benjamin and Christian disagree with this deal. Is this purchase contract legally valid? Adam has unlimited power to represent the OHG because according to the law, every partner can represent the OHG by himself. Unless there is a specific clause in the partnership agreement, the internal limitations are irrelevant for his power. It therefore does not matter if A would have needed the agreement of the partners internally for concluding the contract. B and C can only demand compensation in the name of the partnership if they deem the purchase to be in violation of a partner's duty. This, however, does not concern the validity of the contract and the contractual partner who is not part of the OHG. Issues concerning the liability of the partners and their joint ownerships are governed by the principle applicable to partnerships under the Civil Code. As the partner's liability is accessory to the partnership's liability, each partner may be sued directly for the full amount, Section 128 HGB. While the personal liability of the partners may be excluded by agreement with the creditors, it can neither be excluded by limiting a partner's power of representation, nor by the partnership agreement. A partner who has been held liable by a creditor may demand reimbursement from the partnership, Section 110 HGB. If the partnership cannot fulfill this obligation, the partner has a right to compensation against the other partners. Liability to third parties is also imposed upon partners newly joining the partnership. The liability extends even to the partnership's obligations, incurred prior to entry of the new partner. Partners withdrawing from the partnership may be held liable for obligations incurred prior to their withdrawal if their claim becomes due within 5 years after their withdrawal. The distribution of profits and losses, dissolution and liquidations are all carried out according to the principles as set out in regard of the partnership under the Civil Code. However, a commercial partnership is not dissolved in the case of a notice of termination by a partner, the death of a partner, or the bankruptcy proceeding against a partner. The Commercial Code allows for the dissolution of the partnership by court decision on petition by a partner alleging and proving good cause. Membership in a partnership may be acquired by inheritance or succession, if the partnership agreement so provides. But because of the personal trust required in a partnership, the heirs to a partner to not become partners when such provision in the agreement is missing. There are several ways to design those agreements of succession. The partners can exert more or less control over the person that can succeed a partner depending on how much interest they have in having a specific person as a successor. In contrast to a general partnership, the limited partnership, so-called Kommanditgesellschaft, KG, consists of two different groups of partners. We have the general partners, so-called persönlich haftende Gesellschafter, personal liable, also called Komplementäre, and the limited partners, so-called Kommanditisten. The liability of a limited partner vis-à-vis the partnership's creditors is limited to the specific amount of his or her actually paid in contribution. Once the entire contribution has been submitted, the liability of the limited partner to third parties is preempted. To the extent the contribution has been repaid to the limited partner, it is deemed with respect to creditors never to have been made in the first place. As previously stated for general partnerships, the liability of general partners, Komplementäre, is unlimited. In fact, most limited partnerships today are GmbH & Co. KG or Unternehmergesellschaft UG & Co. KG, where the general partner is a limited liability company or a Unternehmergesellschaft. As a result, only the corporate entity acting as general partner is fully liable and no natural person. With this trick, you can set up a company which unites many of the advantages of a partnership and of the corporations. However, the law provides that several rules of the corporation apply to the limited partnership with the corporation as a general partner. For example, there are stricter rules in place when it has to file for bankruptcy. All other principles governing the general partnership also apply to the limited partnership, with one exception. A limited partner may not represent the partnership with regard to third parties. They can only represent as a normal agent with a separate power of agency that is detached from their status as a partner. With this, we have reached the end of our first podcast and will continue in the next one with a corporation.